Property Matters here on Dublin South FM. You can contact the show on Twitter, Facebook or LinkedIn at iPropertyRadio, or indeed email the show at hello@iPropertyRadio.com. Your host for today is myself, Carol Tallon, and I'm delighted to be joined by Sally-Ann Sherry, Senior Counsel of Bartra. Thank you so much, Sally-Ann, for joining us today. Today we have a topic that we have danced around on the show, so I'm hoping you're going to dispel some of the myths, maybe clear up a few things for us and try to separate some of the more controversial headlines from the reality. So today we're going to talk about judicial reviews. Thank you for being brave enough to join us. Sally-Ann, you have been quite a vocal voice. As I mentioned there, you're General Counsel of Bartra, and you and indeed the organisation have been quite vocal about the issues and the challenges for judicial review, and perhaps a lot of this comes back to the law of unintended consequences. But you might just, for people listening in, you might just give a little bit of legal context around judicial review applications.
Yeah, so a judicial review is supposed to be about a point of law. It's supposed to be where the procedure that was followed in the decision-making process is challenged, as opposed to the decision itself. The merit of the decision is not meant to be something that the court is to look at. It's to look to see that the procedures were followed in a fair and proper way. And I suppose what has happened is that the planning process is so fractured at the moment that planning decisions are ending up in the High Court under a judicial review, where, you know, ordinarily they should never be in a court, because, you know, the proper place for planning decisions to be made is in the statutory planning authority and not in a court. So something has gone wrong, and I suppose all we can do is identify what we think might have gone wrong and how we think you might be able to make changes to assist that. But I suppose as the developer, we have a perspective, and everyone will have their own perspectives, but I'm happy to share our perspective on it. But I suppose it's not necessarily the only perspective, and you know, we listen to others as well. But just in terms of how I think, you know, we got here, in 2017, it was generally taking around 18 months to get a planning decision for a substantial development. And it was recognised, and is still recognised, that we have a housing crisis. So in order to increase supply and in order to put some efficiencies in the system, the government brought in the strategic housing development legislation. And that legislation attempted to put very strict timelines around planning decisions, where previously, in our experience, it was taking about 6 months to get a decision from the local authority, and then another 12 months, roughly speaking, to get a decision from An Bord Pleanála. And in our experience, those decisions weren't necessarily going to judicial review. So after 18 months, you had a decision one way or the other. Then the SHD, or the Strategic Housing Development Legislation, it brought in a situation where you had a pre-application period, you had a 16-week period with An Bord Pleanála, then you had a decision. So, you know, from the industry's perspective, and in terms of housing supply, quick housing supply in a housing crisis, that was a good idea. But what has happened since then is that so many different stakeholders have objected to the way that the decisions have been made, to what they perceive to the limits on the ability of public participation or the local authority or whoever to implement into that decision, that they feel they have no choice at the end of the An Bord Pleanála decision but to go to the High Court. It's all that they have left, and if that doesn't work, they could go to Europe. So, you know, it's ended up in a situation, and in our experience, because we have a couple of cases before the courts in judicial review, and I suppose they're not our cases, they're An Bord Pleanála cases, but we are impacted by them. I would rather know we were back in the 2017 decisions, where at least when you get a decision, you know what it is, than this situation where we just don't know when we will ever get a decision and what it will be. Because in this scenario where applicants are making applications for judicial reviews, when the date, and there's always a couple of months while we figure out, you know, is a board plenála going to defend that decision? Are they not? And in those couple of months, we as the notice party can't do anything. We have to wait to see, and sometimes the cases back to themselves, the court approves that or they quash them. But there's just so much uncertainty that it's very, very difficult to see a way out of it right now.
Yeah, no, I can appreciate that, and what you're saying is absolutely borne out by the figures. The increases in instances of judicial review have really, they've absolutely escalated. And in fact, just earlier today in the Irish Times, I was reading that 48% of all the planning permission that was granted for units under this process are subject to judicial review. 48%. So let's step back a bit so we can actually see, you mentioned there something has gone wrong. There's certainly no doubt about that, but let's take a step back and see what has gone wrong. So the judicial reviews, what is driving these other than, you mentioned there that people feel they have no other route. So therefore, because they don't have the mechanism to challenge the decision, they're challenging the legality of the decision making.
Yeah.
But what is driving the desire to change the decision?
Yeah, so I suppose I can only comment on what I perceive from having read the cases and read the media reports. And if you take that, there's a 9-week lead in to in the pre-application time period, and then there's the 16 weeks. So the 16 weeks starts on your planning application date. On that date, the developer must publish its website with all of the details of the proposed development. A week before that, they should have had the newspaper and the site notice erected. So it should be evident to the public from that date on that a planning application has been made. They have 5 weeks then in terms of putting in public objections. And I've heard commentary around, that's not long enough. There's too many pages for them to review. They need to take advice, etc., etc. So there seems to be a lot of criticism that that's too short and not enough. And then I think another piece of that is that even if they do put in their objections, and you'll see some developments could have hundreds of objections, it's not necessarily clear in the board plenála decision that those objections have been considered. And it may be that they were considered, and it may be that the local authorities' views were considered, but that's not necessarily making its way into the decisions. So therefore, when the decision comes out, and in the case where it's a positive decision for the developer, the residents and the objectors feel like, I put in my objection and it wasn't heard. Maybe it was heard, but it's not clear from the decision. So there's this gap between the communication and the way that the board is presenting its decision seems to be open to a lot of criticism in the court and in the judicial review procedures, because they're a lot of times you see them say, you made the decision, but you didn't show how you got to that decision. And sometimes that's the reason why a case is remitted or quashed, is because even though it might have been the right decision, they didn't show how they got to it.
Okay, there's two very distinct and different points there. One is around the time frame for public consultation. 5 weeks would seem like a reasonable amount of time for people to be able to raise an observation, to get involved in the discussion. 5 weeks does seem reasonable. It seems to me that if people do engage with the process and they don't see their engagement reflected in the outcome, and by the way, it's not necessarily that what they've asked for is followed, it's that it's acknowledged.
Yeah.
Is that maybe something that has been missing? Is that something that might potentially be a short-term solution?
Maybe, but at the same time, I suppose it's this human feeling of being heard. And, as a developer, we have no issue with the community being heard, with objectors being heard, with the local authorities' views being heard. But at the same time, I can't say that An Bord Pleanála should have to list all of the different objections, and because in some of them they get hundreds of them. But I think it's all compounded by the fact that there's a lot of commentary around SHD blocks out the local authority, which I don't necessarily accept, because I think we have to take a lot of the local authorities' views into account, and we either go forward with their support or not. So there's a lot of this commentary, and it's not necessarily borne out by the actual procedure that occurs within that 16 weeks, but that's what people think and that's what people feel. And it's generating a lot of frustration. It's generating a mistrust with the community in the SHD process in particular. And I suppose that's generated also by, this litany of cases, because every case that is granted leave for judicial review, it gives confidence to the people coming behind it that the SHD legislation is somehow defective. And that's why they're all being permitted to take judicial reviews. So it's this circle. And I don't necessarily have the answer to how they fix it, because I think at this stage it's broken. And the announcement in the last couple of days that they're going to wind it up in October, we have no issue with that. And actually, if you were to ask me what would we ask for them to do quickly, it would be to give us the choice next week that we can either use SHD or we can go straight to the local authority. Because at the moment we have no choice. If it's over 100 units, we must use the SHD legislation. And we have no confidence in it. So we would rather have the choice, but we don't have it. And we're going to have to keep making SHD applications until October, with this statistic showing that every application we make is likely to end up in the High Court in a queue. Whereas we would rather, at this point, the certainty of going the traditional route.
Sally, and one of the criticisms levelled is that the process we have now is exactly what the industry lobbied for. Is that the reality?
Look, our view, and I've sort of discussed this with my own colleagues, our view is that what we wanted was certainty of timelines. We were at this 18-month approximately. That's 4 years ago, 6 months for the local authority, approximately a year from An Bord Pleanála, could be a year and a half with An Bord Pleanála, depending on how complex the case was. All we wanted was timelines. So, it didn't necessarily have to be as compressed as it is now. But I don't accept that the industry asked for this and got this, and therefore, we don't want what we've got right now. We didn't ask for something that's so easily open to challenge that every case is arriving in the High Court. We would rather have a procedure that's trusted by the community, by the stakeholders, by the local authority. At the end of the day, we're better working with these people. We're better listening to them, because it feels like they're all going to court because they don't trust the legislation. They don't trust that they have been heard, that proper procedures have been followed. So,
Sally, Ann, on the website for the Public Consultation Institute of Ireland, there is actually a quote which reads, "Being heard is so close to being loved that for most people they're indistinguishable." And that's so true. So whether you're dealing with somebody in a personal capacity, in a community setting, in a professional capacity, it's exactly the same. As an advocate for placemaking and involving the community in placemaking, planning is a public function. So what role do you see the community has in placemaking?
Well, and I would, this is part of what we do anyway in our day-to-day, because we believe that we need to engage with the communities that we're developing in, because if we don't, then they won't understand what we're trying to achieve, and they'll object to it on all levels, whether that's on a personal level, on a social level, on a community level. So I suppose from our perspective, when we are planning a development and we're preparing a planning application, what we try to do is engage with the local community, explain what we're trying to do, why we're doing it, and we're in a live situation with a substantial development in Dublin at the moment, where we've done all those steps. You know, we've taken space locally, we've shown the model, we've explained, we've sent out leaflets, you know, and it's all part of educating the community about what we're trying to achieve and that we want to work with them. So I suppose like that's only the business side of the developer communicating. When we get to the planning application side, I would, you know, it would be preferable that nothing is coming as a shock to people, and that they know that there's going to be a substantial development. They know why it's good for maybe the 15-minute city concept, or, you know, the generation of their community, and that what, you know, we intend for it to add to their community, not to have towering blocks that, you know, puts a shadow over them and their community. That's not what anybody's trying to achieve. So I suppose we have responsibilities as a developer to communicate, and then I think the state and their systems has a responsibility to listen and to make people feel that they're heard, so that we don't end up in this quagmire again, because I feel a lot of it is because people didn't feel that they were heard.
Yeah, I know. I think you're absolutely right, and I think it's an important step to address. But and by the way, it's one that Bartra has actually taken steps to address, and we know that because 2 of your correspondence that have been sent into the department were made available under the Freedom of Information. So we're going to touch on those now in a moment. But before we do, just because we've talked about the role of the community, just to, I suppose, to look at the political, I don't want to use the word interference, but it's very difficult to find another word to say, you know, the political wrangling that goes hand in hand with new development, unfortunately, really shows up the 4-year election cycle. So you can almost time the reaction based on where we are in that cycle, which is massively unhelpful and was one of the contributing factors to the push for the strategic housing system that we have today. But for the local authority, you know, we know that our new system will likely involve going back to the local authority. How can that be done in a way that is reflective of the community, but isn't subject to the whims of the opposition of the day?
Yeah, well, look, if I had the answer to that, I could solve a lot of problems. I suppose what we need to keep coming back to on this topic is that this is about housing delivery. And, you know, a lot of the criticism about development is about, you know, I don't know, it could be environmental matters, it could be density, it could be height. But at the end of the day, everybody needs to focus on the fact that we are in a housing crisis and we're trying to increase supply. So whether someone is in government or whether they're in opposition, they cannot argue with that. So let's work together, because it's really not helpful where, you know, one party proposes something and the other party, you know, objects to it and rallies all the troops to object to it just because it's the other side's idea. Yeah. So, you know, and unfortunately, I don't have an answer overall, but I think that all of the parties, all of the independents, they should be under pressure to consider that what they're doing, if they are rallying the community to object to something that otherwise maybe isn't, you know, it's a good idea maybe, but that they're just objecting to it for the sake of it. That's definitely not something that...
Let's call that what it is, this element of NIMBYism, that's not in my backyard. Now, I definitely don't fall into the school of thought that all opposition to local development is NIMBYism, because I know from experience that's not the reality. However, a certain chunk of it is, and one of the failings in our current system is that sometimes the minority of people, their voices can be heard very loud and disproportionately so. And in the past, I think our system, the planning system, has been very poor at capturing the silent majority. And it's one thing that we've seen change with the use of digital tools, by making engagement so much more accessible, when people don't have to walk into a town hall after work when they don't have childcare, or they have other commitments, or they're stuck sitting in traffic on the 2-hour commute, which hopefully we won't all be going back to. The reality is, these are not people who tend to engage in traditional town hall events. So by taking the consultation through digital tools, we have an opportunity to capture a much broader cross-section of the community, and in a way we have the opportunity to amplify those voices that by and large are in the majority. They're not the minority, they're the majority, but they've just been silenced by our current system. Is that something that you see has the potential to shape this as we look at new policies and procedures?
Yeah, like one of the things that, just a small idea that we had was that in the SHD objection window, in that 5-week window, that should be online. Like it should be possible for people who want to make an observation to make it on an online application form, not the rigmarole that they have to go through at the moment. Why would they have to do that in this day and age? And at least then they might feel, well, I sent in my couple of lines, I explained where I live and explained the impact it had on me. Whereas, in certain communities, it's hard to see how everybody there will take the time to write a letter, put it in with their €20, whatever way they have to do. And there's small tweaks like that using digital tools, I think we can engage people a lot better than we have. And, while I don't want to get into the sort of divides of communities, you will see that in certain communities, there's much louder voices on the, the NIMBY side than other communities, and sometimes that's because they have a lot of backing, whether it's financial or it's political or whatever. But it should be an even playing field. It shouldn't be about how loud you can shout with how much money you have to shout. It should be that everyone has a fair chance to be heard where appropriate.
Yeah, we talk about fairness and balance, and sometimes it's seen as if the community is certainly disadvantaged when compared to maybe a development entity or organization. And I know from a personal point of view, about 18 months ago, I got a little sliver, not even a note, but a sliver of a note. So obviously, a photocopy that had been torn up to 3 or 4 or 5 times. And it was quoting a planning application number, telling me where to go to raise an objection because the traffic flow, or we were essentially, it came through the letterbox with no information as to where it came from, no information about the development, but telling us what we should think and where to go. And if a developer did that, it would be so far beyond a judicial review. So just when we're talking about leveling the playing field, there has to be a certain amount of accountability and shared responsibility. But look, rather than kind of get stuck down that rabbit hole, I mentioned earlier in the interview that 2 of your letters have been made public through the under Freedom of Information requests. So I'm going to start with the most recent one, a letter that was sent to our Taoiseach in April. So you might just give a little bit of background as to what prompted you to do this.
Yeah, well, I suppose to go back to the first letter, which was in December, which we can come back to, I suppose that was December. My letter to the Taoiseach was in April, and my perception was that nothing was changing. The cases were, racking up in the High Court. Every week there was a new one. And to a certain extent, it was a case of, who do we write to here? Because every sounding that we were trying to take was that this is not This is not for the housing minister. It's not. It's perhaps they say it's a judiciary issue, so therefore it's the Department of Justice. That you've all of this sort of whose problem is the judicial review system. So that's why we wrote to the Taoiseach to say, we're not sure. It seems to be a whole of government issue. So can you get whoever needs to be involved and bring them together? And I suppose the context of my letter was all of the work that we were doing at that point in relation to our preparation for the planning application for O'Devany Gardens, which I can't go into the planning application itself, but I can comment about the sort of preparation from a judicial review point of view. So that was the end of April, and around the time that I sent that letter, we had all of our planning application ready as far as we were going to have. And that's reports upon reports upon reports. It's pages and pages. That entire application was passed to a law firm in Dublin to review. Like, they're reviewing the BAT reports, they're reviewing, construction reports. And it's on the basis that we had to task them to look at all the judicial review cases that had occurred and check that we weren't tripping one of the issues that were identified in those cases in our reports. And actually what happened was we were ready on, say, a Wednesday to submit our application, and another case came out of the judicial review in the High Court with another factor that we had to revise documents. We had to hold the planning application for another week, and then we put it in. But at that point, we had to say, we can't hold this any longer. There's only so much we can do to judicial review proof something, that we're going to have to let it go. And it goes in. And I suppose, given the statistics, my point to the Taoiseach was that I felt that no matter what we did, no matter how much money we spent on the preparation, it didn't matter what was in the application. It actually doesn't matter how many units or how high, it will go to judicial review, because the way that the statistics have lined up, the conditions that it is to get leave to apply for judicial review right now, I can't see that particular case not going to judicial review.
You see, that element of inevitability really shows how far the rot in the system is.
Yeah, and I suppose you see what I think. Sorry, Carol. What I think is really interesting is you see commentary then from councillors and politicians saying, yeah, she's probably right. It probably will go to judicial review when you look at the height and the density, etc. Like, what has that got to do with judicial review? They shouldn't be pre-deciding that depending on what height or what density that it should go to the High Court, because it's for An Bord Pleanála to decide if you're within the rules of An Bord Pleanála's decisions and that they make their decision in a proper way. But that's how far we've come, that when I say I feel it's inevitable and the politicians say, yeah, I think she's right, in
a way that actually brings us full circle around to how we started by setting out what a judicial review is. And a judicial review was never about reviewing the decision that was made.
No, it's not supposed to be about what height, what density, what size, what it is, what tenure. It's not meant to be about that. It's about how An Bord Pleanála reached their decision. Did they follow fair and proper procedures to get to that decision, not the decision itself?
Well, you mentioned there that you did, in fact, before your letter in April, you did, in fact, last December, write to our Housing Minister, Darragh O'Brien, and in that, you didn't just write outlining your frustration, you actually talked about things that potential solutions. So the one thing that in fact sometimes the industry has been criticized for, you actually put forward solutions. So we'll just take a few moments to talk through those if we can. I have the letter in front of me, and I've no doubt it'll be in the Sunday papers this weekend. I suspect. But I suppose maybe first of all, I think just to explain where Bartra sits in this. How many applications approximately are you dealing with at the moment?
So I suppose, we have lots of different sizes of developments, but in basic numbers, we have 2 in front of the High Court Judicial Review at the moment. One of them is on its second round in the Judicial Review. It's its second Judicial Review for the same site. We have 4 others that we're holding our breath on. We just don't know. And they're not all SHD, because unfortunately the infection of judicial reviews is not just limited to SHD. You do find it on anything that's anyway controversial, depending on where you're trying to build, what you're trying to build. The local communities are, buoyed up by the frequency of judicial reviews on SHDs, and it's now starting to impact on normal decisions. So I suppose that brings me to maybe some of the suggestions that I made in that letter. And that letter, and I suppose I would hope, but I'm cynical, that, that list of suggestions, that was a long list of, you could do this, or we don't know the answers. We were just trying to be helpful to say, in our experience, this is happening, and perhaps you could tweak it this way or that way. So to pull one suggestion on its own, maybe doesn't give the reflection that there are lots of suggestions and we don't propose that they're all implemented, or, they're just ideas. So, and a lot of our suggestions came as well from, there is a heads of a bill from 2019, and it's actually the same heads of the bill that I saw Minister Peter Burke talk about in the last day or two that they're reviving. And when we saw that, when we reviewed that, they had a lot of the ingredients of what we were proposing anyway. And you have EU law and the Aarhus Convention, etc., and you have to give people a fair chance to object. And I suppose there's nobody saying that people shouldn't have that fair chance. And I suppose there's nobody saying that you make it prohibitively expensive, that they can't do that. And the heads of the bill, which reflect, broadly speaking, what we were proposing as well, the heads of that bill, while they propose, amounts that people might be subject to if they lose their case, or, that there will be some financial consequences if you take a case and you don't win it. That there would still be discretion for the court to waive that. So it's not that it's a clear cut, you would have to pay 5,000 or you'd have to pay 10,000 if you're an entity or whatever. It's to say that there's some parameters around it, and that there's some parameters around being responsible for the other side's costs, which makes sure that people just pause that second and say, am I taking this case for the right reasons? And that there will be some consequences because of what it's doing to the supply of housing and what it's doing to the parties who are trying to develop in terms of time and money and costs that it's costing us for every judicial review that's taken. So there's the sort of, there's the ones that you hear all the time, like people should have a personal connection of some kind, that, I'm from Donegal and I could be, up in Donegal objecting to something in Cork with absolutely no connection to it. So, and it's
you mean we could be in Wicklow objecting to something in Athenry? That would never be allowed.
Yeah, and that, we saw that, and it's still the case. So we didn't learn from it. And it's in the draft of the bill, but it's not yet in. So I suppose I would welcome that type of thing. There was another few things.
We might just run through one or two of them quite quickly, because I know we're caught for time, but just one of the things to point out here is that personal responsibility and accountability for the actions that are taken are massively important. However, I think we also need to point out that this, in a lot of ways, it's the system that's failing the people, not the people failing the system.
Absolutely.
I think that people who are feeling quite desperate are looking at the only route they feel is available to them. So essentially what we've done is we've allowed a system that's open to manipulation and to abuse, but the people abusing it are abusing it because they feel they don't have another option. So I suppose it's really important that we don't position this it really is the system that's at
Yeah,
fault here.
absolutely. Like, we're not saying there's no villains in this. There's a broken system, and that, it needs to be balanced for them and for, and if you think about on board Planola, they can't be having a good day either. They need more people. They must need more people. They have so many decisions and so many legal cases. So there's so many people that are losers in this.
Oh, no, absolutely. And actually, I think what you did, what you've done on behalf of Bartra in this letter, which hopefully, you mentioned that you've seen some of this actually going in then to the...
Well, it was in the bill already, you see. So and we were saying, yes, it's in your bill. And you see, the thing was, the bill was prepared by, I think, Fine Gael at the time. And then by the time we were writing, the Minister for Housing was Fianna Fáil. And I suppose it's to encourage that just because Fine Gael drafted it doesn't mean that it's not a good bill. And, would you look at it too, please? So, and it was to, suggest a few things around how it was impacting us and how the bill might help. But in terms of the few things that we suggested, I suppose one of the things was that if somebody didn't make submissions during the planning application, that they couldn't then put in a judicial review at the last minute, that they had to show that they had followed right through and that they had good reason for their arguments. And that, I suppose, like, I hate using the word frivolous because I don't like the word. I don't believe that people are doing these things for frivolous reasons. I believe that they believe that they have good reason to do them. But I suppose I don't think that criticism of cases would occur if people were heard better, and that, that the reasons they were taking the cases weren't understood. And that they didn't feel like their submission made a difference in the application. So I suppose it's that kind of balance between somebody who's completely unconnected to a development, in my view, unless it's some very technical environmental reason, that they shouldn't necessarily be able to just put in, submissions left, right, and centre, or judicial reviews left, right, and centre. I think you should have to show some, either what they say in the legislation is some, or the draft bill is some personal or peculiar reason that you are affected by this development. So that kind of thing, and and we touched on the costs. I think that it's important that there's some implication, because, like, if you look at, one of the statistics I've heard recently is that 94% of the SHD cases that are challenged, that they're lost, whether An Bord Pleanála quashes or loses the case. In that scenario, An Bord Pleanála is picking up the costs for its own lawyers, and it's picking up the costs for the other side. So, you would have to think that there has to be a lot of, no full, no fee type arrangements because of the success rates.
Yeah, and that's entirely wrong for a whole... that goes broader than just planning. Yeah, no, absolutely. So I just kind of a quick run through here. Some of the proposed there, and I absolutely accept what you're saying. No one of these is a silver bullet, that they need to be looked at.
And all need to be assessed fairly.
Absolutely, but judicial review should only be possible after An Bord Pleanála determination. Textual errors in decisions should not be a ground for judicial review. I actually didn't realize that it was. So I was really surprised when I read this here.
There's no, at the moment, if you see some of the reasons for the judicial reviews, there's no materiality. Like, it's not our case, but I read in the press about one of the cases where the judicial review was granted because the BAT report that the board received a hard copy of was different to the one that was online. So the BAT report brought down the whole decision. Yeah. So, there's no materiality there or ability to fix it, because we're all human. So that is going to happen. And it doesn't matter how many times we all check, there's always going to be, immaterial items. I'm not saying that BAT report wasn't material, but the mistake wasn't material. It could have been checked. It could have been corrected. But yet the developer sent back to square one.
Yeah, I know exactly the development you're talking about, and yeah, it is a particularly poor example. So, I mean, you've spoken there about the substantial grounds and sufficient interest, which absolutely
Yeah.
makes sense. Um, there's one there, amend non-governmental organizations automatic standing right to expanded qualifying criteria.
Yeah, so that particularly relates to the environmental cases, and I suppose yeah, it's not so. I suppose it's more relevant to the sort of the wind farm and the environmental type cases than I suppose the pure real estate that I'd be looking at.
Okay, and you did actually, I mean, look, we won't go through all the rest of them, but there were further items to be considered. And I think that these are things that are entirely reasonable. As I said, I suspect we'll see some of these appearing in the Sunday papers this weekend. But you touched on one there, in relation to kind of no fresh grounds, that absolutely does make sense. It seems to me, though, that we're coming to the end of the life of this process.
Yeah.
Before we finish up, what do you think is likely? What are we likely to see?
Well, I suppose today, unless something happens between now and October when the SHD process appears to be proposed to terminate, we're going to continue with these SHD applications and we're going to continue with judicial review proceedings because the bill is only going before the Oireachtas next week. Or it's going before them before the summer recess, and then all the other stakeholders have to input into it. So it's going to be months until. And, we've seen legislation go through very quickly in this country when it's needed, but I suppose I don't feel confident today that anything's going to happen this side of the summer, and then we're into kind of September, October. So I think that we're going to continue to bleed for the next few months until we get to October. What I would ask, if I was to ask anything, if you were to ask, what would you ask? It would be that we get the choice very quickly to go either with an SHD application or a traditional local authority application, that we're not obliged to use SHD at a time when we believe the system is completely broken.
Okay, if that choice was made available, do the local authorities have the resources to handle capacity? I mean, you mentioned there that An Bord Pleanála is struggling under the weight of applications. If a certain amount of those were to divert, probably a large amount of those were to divert to the local authorities, what capacity is there?
Yeah, you see, I suppose the problem seems to be that 4 years ago this legislation came in and the board was tasked with all of this without really being given the resources that they needed. Mm-hmm. So I'm not clear whether the resources were in the local authority to start with, but certainly the decisions were coming out of the local authority within a couple of months and then getting stuck at the board level, up to 2017. They're now going to the board, but the board doesn't seem to have enough manpower or enough resources to give decisions that tick all the boxes to be able to show that they followed the procedures properly, and it's not to say that I'm sure they are doing their best, and I'm sure there's nobody less satisfied right now than the people who are trying their best in there to come with decisions to allow housing supply. We're all doing our best, but something has gone wrong, and if the local authority need more resources to take it back, then give it to them. But this is all about supply and units, and right now it's at a standstill as far as we can see, because every decision we make right now is on the basis that if we buy that site, if we do a planning application, if we try to fund something, if we try to buy something that's subject to planning, all of those decisions are impacted by this judicial review at the end of everything.
Okay, Sally-Ann, it almost feels like an unsatisfactory end, the fact that, in this kind of conversation, we don't really know where it's headed, and we don't even know if the solutions that are likely to be proposed will actually solve the problem. You know, this just feels like one other place in a leaky ship. It's one other leak in a leaky ship. But listen, thank you so much for going through and setting that out today, and really bringing some clarity and dispelling some of maybe the misunderstandings around judicial reviews. That was Sally Ann Sherry, General Counsel of Bartra. Thank you for listening in today. That's it from us on Property Matters on Dublin South FM. You can get in touch with the show on social media at iPropertyRadio, or indeed email hello@iPropertyRadio.com. My thanks to Peter Rice on sound. We're back at the same time next week. From myself, Carol Tallon, and all the team here at